A tax on firearms is unconstitutional because it creates a chilling effect. I'll explain. There are legal principles and constitutional protections in the United States that are designed to prevent the government from imposing taxes that create a chilling effect on the exercise of a constitutional right. Now, we're hearing this argument a lot with respect to suppressors and the National Firearms Act of 1934. So what is a chilling effect? Well, chilling effect occurs when laws or regulations, including taxes, discourage individuals from exercising their rights out of fear of penalty or burden. Those who have been trying to remove firearms from Americans since our founding have tried every possible way around the Second Amendment, and imposing financial burdens upon their fellow citizens has worked to some degree. In this case, we're talking specifically about a financial burden imposed by the 1934 National Firearms Act on suppressors. But the chilling effect is not limited to suppressors. It's not even limited to firearms in general. The NFA imposes a $200 tax on suppressors, which at the time of the enactment was a very high amount. The original purpose of the tax was to suppress ownership. Now, even back in the 1930s, they knew that imposing a tax on specific firearms would create a potential for people to violate the law by failing to pay the tax. This would then lead to prosecution. And not necessarily for the carrying or possession of that firearm, but the violation of the imposed tax was enough to achieve their desired result. Well, Representative Madeleine Dean, a Democrat from Pennsylvania, said the quiet part out loud in a House Rules Committee hearing. She said, "Why do you think they put such a steep tax on that silencer in 1934? Take a look at the history. The history is the tax was used to try to discourage the purchasing of silencers." Are they just full of themselves to the point that they have no sense of constitutional boundaries? Or do they simply not understand the unconstitutionality of taxing a right and the chilling effect it creates? Well, in light of the New York State Rifle and Pistol Association versus Bruin case in 2022, courts now must evaluate gun laws based on text, history, and tradition, not what may or may not be in the public interest or what politicians may declare will keep people safe. This shifts scrutiny toward historical consistency. Was there a tradition of taxing or requiring the registration of suppressors at the time of our founding? No. There's no evidence that a specific federal tax on firearms or accessories was enacted in the early years of the Republic. As a matter of fact, there are many gun laws on the books today that face extreme scrutiny for that very reason. Now, the first major federal law taxing firearms didn't come until much later with the infamous National Firearms Act of 1934. But the idea of chilling the exercise of a constitutional right not only fails to meet historical tradition, but it also has a long list of contradicting precedents when it comes to other constitutional rights. Now, while there may not be a single statute or law that uses the exact term chilling effect, courts, especially the U.S. Supreme Court, have repeatedly ruled that government actions, including taxes or fees, cannot be used to deter the exercise of constitutional rights. Now, in Grosjean versus American Press Company in 1936, Louisiana imposed a special tax on large newspapers. Now, the Supreme Court struck down the tax, saying it was an unconstitutional burden on the press and had a chilling effect. The case established that even facially neutral taxes can be unconstitutional if they selectively burden rights. In Murdoch versus Pennsylvania in 1943, a city required a license fee for religious solicitation. The court struck it down, holding that you cannot tax the exercise of a constitutional right. In Spicer versus Randall, 1958, California denied tax exemptions to veterans who refused to sign loyalty oaths. The court found this to be unconstitutional as it placed the burden on the individual to prove their loyalty, chilling free speech. And in Minneapolis Star-Tribune Company versus Minnesota Commissioner of Revenue in 1983, the court invalidated a use tax that applied only to paper, and ink used by large publishers. Again, recognizing the chilling effect a tax imposes on the freedom of press. Well, suppressors are considered arms, and arms are clearly protected by the Second Amendment, and a tax on arms creates an unconstitutional chilling effect. Now, the irony is, Democrats understand that a taxation is for the purpose of deterring the exercise of a constitutional right. The fact is, they simply don't care. And we haven't even touched on the unconstitutionality of registration requirements also imposed on American citizens under the National Firearms Act. More on that next time. Thanks for watching Bullet Points. I'm Dan Wass for Gun Owners Foundation. You can find more Second Amendment content and updates at gunowners.com.